My name is Hailat Baluka, reading the judgment of Honorable Lady Justice Lillian Tebatemwa, Justice of the Supreme Court, in the case of Odeke Peter and two others as appellants versus Uganda as the respondent. Judgment of the court. This is a second appeal arising from the Court of Appeal's decision which upheld the appellant's convictions and sentences imposed by the High Court of Uganda at Jinja Circuit. The appellants were indicted for the offense of murder contrary to sections 188 and 189 of the Penal Code Act. The three appellants were each tried and convicted and sentenced to 25 years imprisonment. The facts as gathered from the lower court record reveal that on the 11th day of June 2007, the appellants went to the home of the deceased. The trial court found that by his confession, the first appellant admitted that he lured the deceased to a garden where he strangled her. He then sought the assistance of the second and the third appellants. The trio dumped the body in a bush behind her pit latrine. A week later, the body was recovered by the deceased's grandchild. Investigations led to the arrest of the appellant. Upon arrest, the second and third appellants made charge and caution statements implicating themselves singularly and severally, including the first appellant. After a full trial, the High Court convicted the appellants and sentenced each of them to 25 years imprisonment. The three appealed against both the conviction and sentence. The Court of Appeal dismissed their appeals, upholding the convictions and sentence. Dissatisfied with the decision of the Court of Appeal, the appellants appealed to this court on the following ground: that the land justices of appeal erred in law when they upheld an illegal sentence which is inconsistent with previous judicial precedents. The appellants pray that the appeal be allowed and that the sentence of 25 years imprisonment be substituted for a sentence of 20 years imprisonment. At the hearing of this appeal, Ms. Sarah Awelo appeared for the appellants on the state brief, while Ms. Happiness Ainebiona, the Chief State Attorney, appeared for the respondent. The appellants were present in court and both counsel proceeded by way of written submissions, which this court relied on in arriving at this judgment. Ms. Awelo, counsel for the appellants, submitted that this appeal is premised on the ground that the prison sentence was illegal and inconsistent with previous judicial precedents. She further argued that the 25-year sentence was harsh and excessive. She relied on Kiwalavye Bernard versus Uganda, Supreme Court Criminal Appeal number 143 of 2001, to argue that appellate courts ought to not interfere with sentences unless they are manifestly excessive based on wrong principles, or if the trial court failed to consider material factors. Counsel placed emphasis on the principle of consistency in sentencing, relying mostly on Kamia Abdallah and four others versus Uganda, and Arikihundira Houston versus Uganda, where she argued that the years of imprisonment ought to align with established sentencing principles. Counsel for the appellant submitted that the court is responsible for maintaining consistency in cases where similar facts, when handling appeals, related to sentencing. Counsel prayed that the appeal be allowed and the sentence of 25 years be substituted with one of 20 years imprisonment. Ms. Happiness Ainebiona, for the respondent, invited this court to not interfere with the sentence of 25 years, contending that it was neither excessive nor based on any error in principle. Counsel distinguished the cases cited by the appellants, asserting that they involved different factual circumstances. Counsel argued that the appellant's actions demonstrated premeditation, malice aforethought, and cruelty as they targeted a defenseless elderly woman over a land dispute. She cited Karisa Moses v Uganda, where the Supreme Court upheld a life sentence for the murder of a family member. Counsel invited this court to follow Akbar Godi v Uganda, where a sentence of 25 years imprisonment for the premeditated murder of a spouse was upheld. Counsel submitted that in the instant appeal, the trial court considered all the aggravating and mitigating factors and found that the aggravating factors outweighed the mitigating factors prior to sentencing the appellant to 25 years imprisonment. The land justices of appeal confirmed the sentences against each appellant. Counsel prayed for the appeal to be dismissed. Determination of the appeal. This is a second appeal. As the Supreme Court, we are not only alive to, but are conscious of the limits of the jurisdiction of this Supreme Court as a final appellate court. The Constitution sets out the limits of our jurisdiction as follows. Article 132, jurisdiction of the Supreme Court, right to appeal judicial decisions. Clause 1, the Supreme Court shall be the final court of appeal. Clause 2, an appeal shall lie to the Supreme Court from such decisions of the Court of Appeal as may be prescribed by law. Indeed, an appeal lies to the Supreme Court from decisions of the Court of Appeal as prescribed by the law. In this case, the law that prescribes the jurisdiction of this court in criminal matters is the Judicature Act, Cap 13, which under the recently released volumes of the laws of Uganda is now Cap 16. An appeal to the Supreme Court from sentence is possible only if it concerns a matter of law of great public importance. Section 5 of the Judicature Act provides for appeals to the Supreme Court in criminal matters. Subsection 3, in the case of an appeal against a sentence and an order other than one fixed by law, the accused person may appeal to the Supreme Court against the sentence or order on a matter of law, not including the severity of the sentence. Courts will ordinarily defer to the discretion of the appellate court and trial courts in imposing sentences unless the sentence raises the questions of law. In Abele Asmani v Uganda, which cited with approval Okello Godfrey v Uganda and established the principle that Section 5, subsection 3 of the Judicature Act does not allow an appellant to appeal to this court on severity of sentence. It only allows him or her to appeal against sentence only on a matter of law. Accordingly, we shall not consider issues of the sentence being harsh or excessive, since that goes to severity of sentence. The appellant has no right of appeal on severity of sentence. In Karisa Moses v Uganda, it was observed that this court has repeatedly emphasized that under Section 5, subsection 3 of the Judicature Act, an appellant is precluded from appealing against a sentence on the ground of severity. In Jamada v Uganda, 2017, it was held that, first and foremost, we have to point out that the ground of appeal on severity of sentence is barred by law. Section 5, subsection 3 of the Judicature Act prohibits grounds of appeal based on severity of sentence. It is straight that an appellant has a right of appeal only against the legality of the sentence, not its severity as stipulated by Section 5, subsection 3 of the Judicature Act. We note with concern that several appellants lodge their appeals against the severity of sentence under pretext that it can pass scrutiny under Section 5, subsection 3 of the Judicature Act. To this end, the appeals appear as undisclosed or disguised questions of law for interrogation before this court. A granular look at counsel for the appellant's arguments exposes her arguments as undisguised submissions on excessiveness of the sentence. She labored unsuccessfully to prove the existence of inconsistency with previous judicial precedents, which loophole the court could use to look into the severity of the sentence passed against the appellants. Counsel for the respondent was none the wiser. She did attempt to delve into the jurisdiction of this court, but rather attempted to distinguish the factual circumstances of the case law referred to, entirely missing the point. In conclusion, we find that this appeal is not brought to this court in conformity with the law, and instead we find that it to be a pretext, an appeal disguised as a question of law, when indeed it is against severity of sentence. We have no cause to believe that these sentences raise a question of law so as to warrant our intervention. An appellant is precluded from appealing to this court on grounds of severity of the sentence. The appeal is dismissed. The sentence of 25 years imprisonment as imposed against each of the three appellants is upheld.